Welcome to CSIS Online. The way we bring you events is changing, but we'll still present live analysis and award-winning digital media from our Dracopolis Ideas Lab, all on your time, live or on demand. This is CSIS Online.
Good afternoon, everybody. My name is John Hamry. I'm the president at CSIS, and I welcome you to what's going to be a very interesting discussion. I come from a defense background. I'm used to talking about warfare, but this is a whole new thing for somebody like me. And when you start realizing the deep dimensions of interests that are at stake, and have to be resolved in a fair, transparent, and enforceable way, we are now going to talk about one of the great challenges and questions that's been unfolding over the last several years. And it's about intellectual property, and it's about how intellectual property is protected and what is in the public interest, what's in the private interest. These are fundamental issues in America. And we're so fortunate to have Andrei Iancu, who was the previous head of the US Patent and Trademark Office, to lead this discussion on the implications for software innovation in the great battle that's been going back and forth between Google and Oracle. Andrei, I'm at the edge of my capacity to be thoughtful here. So let me turn it to you. You're going to lead this conversation for real. Thanks to all of our panelists. I'm so grateful you're here.
Thank you very much, John. And that was a wonderful introduction, actually, because, while this is not warfare in the traditional sense of the word, there is no question that it was a great battle between two very important companies in the United States, Google and Oracle, but also fundamental to the copyright industry, the software industries, software development industries, and perhaps, as we're going to explore during the next hour, to a lot more with respect to innovation in the United States. The Supreme Court's decision in Google v. Oracle that issued just a few weeks ago is certainly one of the seminal decisions on copyright from the Supreme Court. It deals with perhaps an esoteric technology to some of us. It deals with APIs. We're going to explain what that means, and in fact, with a very specific aspect of APIs and what is protected and what is not protected when it comes to copyright, and what are the broader based implications with respect to software protection overall. Some say that this is one of the most consequential decisions for software protection when it comes to copyrightability, to copyright issues. Google, by the way, welcomed the decision, as you can imagine, and said, quote, "The Supreme Court's clear ruling is a victory for consumers, interoperability, and computer science." Oracle, as you can imagine, did not appreciate the decision as much, and they were quite blunt. They said, quote, that Google, quote, stole the Java code and spent a decade litigating as only a monopolist can. This behavior is exactly why regulatory authorities around the world and in the United States are examining Google's business practices. Close quote. That was according to Google. Folks in the industry have been lining up on one side or the other. So to explain all of this, we really have the three, in my view, top experts when it comes to copyright issues in the United States. First, we have Shira Perlmutter, who is the Register of Copyrights and Director of the US Copyright Office, where she leads a workforce of over 400 employees, advises Congress on copyright policy, and directs the administration of important provisions of the United States Copyright Act. Prior to her appointment as Register, Shira served since 2012 as Chief Policy Officer and Director of International Affairs at the US PTO, where I had the great honor and privilege of working with her during my term. She did many other things in the past, including some time at the World Intellectual Property Organization, WIPO, in Geneva, as a consultant on copyright and electronic commerce. Welcome, Shira. David Nimmer is counsel to IRL in Manila in Los Angeles. He also serves as professor from practice at UCLA School of Law, a great school, by the way, and I'm just only a little biased, and distinguished scholar at the Berkeley Center for Law and Technology. Since 1985, he has authored and updated Nimmer on Copyright, the standard reference treatise in the field, first published in 1963 by his father, Melvin Nimmer, who was also a professor at UCLA. By the way, David and his treatise are quoted often and frequently by the Supreme Court and many other decisions, and he is quoted often by both the majority and dissent in the Google v. Copyright case. Welcome, David. Peter Manel is the Corrett Professor of Law and Director of the Berkeley Center for Law and Technology at the University of California, Berkeley School of Law. In 2018, Professor Manel co-founded the Berkeley Judicial Institute, and in 2016, he founded Clause 8 Publishing to promote creation and dissemination of the highest quality and most up-to-date educational references at fair prices. Professor Manel's research and teachings span intellectual property across digital technology and entertainment fields, well beyond copyright, but certainly within copyright, but he's also an expert in patent and other areas of IP, as well as environmental law, policy, property law, and economics. Welcome, Peter. Let me start with you, Peter, actually, and let me ask you, first of all, Peter, to set the stage for us. First of all, before we get into the case, can you just briefly describe the technology at issue? What's an API, just so we can set the stage?
Thank you, Andre, and thank you to CSIS for hosting this. And it's a real honor to be part of a panel with all of you. The Java Application Programming Interface uses the Java programming language, which Sun dedicated to the public domain, to establish classes that contain various methods. Obviously, when we're using computers, we want to be doing things, and methods are the way we do things. For example, the java.security package contains the classes and interfaces that implement the Java security architecture. These classes, such as protection domain, implement access control methods and prevent untrusted code from performing sensitive operations, among other tasks. The methods in protection domain use intuitive labels, such as code source, to perform methods. Without the API modules, Java programmers would need to develop these methods from scratch. More than 6 million programmers have learned the Java language and APIs, making it one of the most widely used programming languages in the world. The declarations declare what an identifier means.
Hold on.
Declarations.
Let me just interrupt briefly, just for a second. So just to set the stage, Sun is a separate company that created Java in the first place some years ago, right?
That's correct.
And the reason Oracle is in the picture here is because Oracle purchased Sun and the Java code at issue, right?
In 2010, yes.
Okay.
But the Java programming language dates back to the early 90s.
Yeah, when it was when Sun developed it, right?
Yeah.
Yeah.
So the declarations declare what an identifier means. They're most commonly used for function definitions and variables. They serve as method calls or shortcuts. They're analogous to the labels that Lotus developed for its 1, 2, 3 spreadsheet menu command hierarchy. The first letter of those command labels could be used to create macros, which were high-level programs to automate spreadsheet preparation. Borland designed its Quattro spreadsheet to run 1, 2, 3 macros, so the companies that had invested in developing the macros could transition to Quattro without having to reprogram their spreadsheets from scratch. The issue there was whether the millions of 1, 2, 3 users were locked into Lotus's product by their use of these method calls. As the name suggests, the implementing code implements the classes and methods within API packages. Such implementations can run into thousands and tens of thousands of lines of computer code. That's why programmers prefer to use declarations to invoke the methods. And that's why the term declaring code is really a misnomer. It's not a term that programmers typically use. Declarations are more in the nature of glossary names.
Okay, so there's obviously the court draws a distinction between declaring code and implementing code. The two in combination make up the API, which is the Java API code. So we'll get to the various distinctions and what legal implications they might have. But before that, let's go back to some of the basics here. Let's look at Google. So Sun was developing Java, ultimately acquired by Oracle, as you explained. But what was happening at Google and Android in the meantime?
Well, it's an amazing story. And if Aaron Sorkin is watching the webinar, Aaron, this would be as good or better than a film than The Social Network. So I think to understand it, we really have to go back to the early 90s and to see what was really behind the whole Java enterprise. So Sun, like Apple, was one of the big breakthrough tech companies in the 1980s. Many people are not as familiar with Sun, but they were, I think, the first billion-dollar revenue company in Silicon Valley. And like Apple, they successfully commercialized important breakthroughs at Xerox's Palo Alto Research Center. They made their mark through the creation of the Sun Workstation product. This was the ultimate tool for programmers of that era. To have a Sun Spark workstation was the best platform to be building. And as part of their business, they had software developers, and one group of software developers created this Sun Java language as really just kind of an experiment. They didn't have a clear product in mind, but they ended up targeting set-top box designs, and they came up with a very interesting language for set-top boxes. But the the set-top box industry wasn't interested. And Bill Joy, one of the iconic programmers at Sun, thought that this language could be redeployed as a way of programming this new thing called a website. And Sun saw this as really a way to augment its workstation business, to have this other programming language out there as the internet was taking off. And the big challenge at that time was Microsoft. Microsoft was such a powerful player in the industry that Sun wanted to make this a publicly available language that would allow people to program websites on all types of platforms, Apple, Microsoft, and others. And that's where this write once, run anywhere idea comes from. And so this was a cross-platform language, and it quickly developed, and Sun became, a very notable software company, even though it wasn't selling the product. It was largely giving it away, it was licensing it, and as it became more popular, the APIs, the pre-packaged modules, classes, became a part of the platform. And Sun used a model that had been gaining attention in the field called the general public license. And they wanted everyone who ran their software to ensure that all implementations would be fully compatible with this platform, and that anyone who built on top of it would make their implementation, their advances, also available for everyone else. And so that was kind of the nugget that ends up being very important as Google is coming on board.
So we'll come back to this because, of course, Sun was making money from the Java code in some way. But let's park that for a second and just briefly tell us what was happening at Google in the meantime with the Android system, and in particular why they started using the Java platform.
Well, I'll just briefly say that the Java part of Sun was really just a way of increasing sales of workstations. It was not an independent profit center. But the story goes, proceeds forward as the internet takes off and Google emerges. We're still in an era in which mobile phone technology is fairly primitive. We don't have any breakthrough products. BlackBerry is one. And there were companies like BlackBerry that were using a Sun, implementations of Sun's Java. But what we saw was this emergence, really with Apple becoming a player. Google was aware that Apple was going to be introducing a mobile phone product before the rest of us, because Apple was going to use Google Apps. And so Google had a group within the company that was developing technology to run on the iOS. But they also got interested in developing a second platform that the founders of Google had gotten interested in, a product that Andy Rubin had developed, and they brought in his group and they started this Android project, really as a secret project within Google. And they didn't know quite where it would go. And it was only after the iPhone appeared and Google perceived that Apple was primed to really monopolize the industry and have tremendous control over that space, that they pushed the Android part of that business. And while working with Apple on the iOS software, they were also developing a competitive strategy. And that ultimately is what causes great conflict between Steve Jobs and the Google founders.
Okay, so just one more question, and then we'll go to Shira to talk about the legal arguments. Ultimately, Google copied 11,500 lines of declaring code from the Java platform. Why did they do that? Apple created its own platform. They didn't take any Java code. Why did Google copy some of the Java platform?
Well, Google, the Android team, was fully intending to work with Sun. They anticipated being able to develop a licensing relationship. In fact, Eric Schmidt, who was Google's chief executive officer, had been the chief technical officer at Sun when they developed Java. And so people thought this was going to go pretty smoothly. There were ongoing discussions. But Google recognized, the Android team recognized, that it would be essential to break into the market to enable people to build the kind of applications quickly. And the fact that 6 million people knew Java was very important. But they didn't want to bring in the entirety of Java. Java was too big a platform to load onto the small chip of a mobile phone. And a lot of the features really had no relevance. There's no keyboard. There are different things that they would want to build in. And so Google's idea was that they would customize this. And that was what they'd hoped to work out. But they ended up reaching an impasse with Sun on two issues. One was the GPL, that Google very much wanted handset makers to be able to build on top of the operating system without making all of that freely available. So they wanted to encourage that innovation and felt that GPL would discourage it. And secondly, they didn't want to take the entirety of the platform. It would not have succeeded to bring in all of that code if you're only using a small portion. And that's why Google was only using 37 of the 166 APIs. And when you say 11,500 lines of code, it's not code. Those were lines that had declarations in them. And that's what Oracle was complaining about. But that's 11,500 out of 2.8 million lines of code in the Java platform. So 0.4% of the platform was part of the Android operating system.
Okay, so, well, that obviously, so that's Google's percentage. It depends what the denominator is, right? Oracle's argument is that it's 11,500 lines and the denominator is just the declaring code, but therefore the percentage is higher. But let me turn now to the arguments before the Supreme Court. Let me turn to Shira and then to David. So Shira, what were Oracle's main arguments, and what was the government's position? And then I'm going to ask David to talk about Google's main arguments on the law.
Well, I can say that the crux of Oracle's argument throughout was that Google used this creative and valuable Java platform code to reduce its development time for Android and to leverage those 6 million Java developers to build apps for Android. And it stressed the fact that it had been engaged in intensive licensing discussions with Google. And when they broke down, Google decided to just go ahead and use the code anyway. So that colored a bit their whole perception of the facts. Now, in terms of copyrightability, Oracle's argument was that the code at issue was very creative. And in fact, not just the code, but the sequence, structure, and organization of the Java library was an original compilation. And it was interesting because Google itself conceded that those elements, that the work was original, but it argued that even original code couldn't be protected by copyright if it could be described as a functional method of operation or system, pointing to language in the Copyright Act.
Which is certainly in the Copyright Act, but isn't all code functional in some way?
Yeah, that's exactly the problem. And so Oracle's argument is, look, Congress defined protectable computer programs as a set of instructions to be used in a computer to bring about a certain result. So by definition, it's always going to be functional. And this is what's always been very difficult about courts examining the protectability of computer software, is that tension. When it came to fair use, so this is an affirmative defense that Google had asserted, and the Copyright Act says that if something qualifies as a fair use, it's not an infringement. And courts have to examine and weigh 4 separate factors. And the first factor is the purpose and character of the use. And in Oracle's view, Google's use was not transformative, which is what the courts often look at, this concept of a transformative use as being something that weighs in favor of fair use. Oracle said, well, look, what Google didn't add any new meaning or expression or message. And in fact, the code that it took served the same purpose in the Android platform as it did in the original. They made the point that every derivative work, which copyright owners have the exclusive right to control under the statute, by definition adds something to the original work or recasts it in some way. And so there has to be some new meaning or expression so that you're not just talking about a derivative work, but something that should qualify as fair use. On the second factor in fair use that has to be examined, it's the nature of the copyrighted work. And here Oracle made the point that both the code and the structure were creative, even though they were also functional in various respects. And then, as you suggested, Andre, on the third factor, the amount and substantiality of the portion used in relation to the work as a whole, Google did copy 11,500 lines of code. And the question is, as you said, what is the denominator, the entire declaring code or the entire work, including the implementing code? But Oracle made the point that the lines that were taken really almost by definition were the ones that were the most important for use in a smartphone platform, and that's why Google wanted them. And then on the fourth factor, courts have to look at the effect of the use on the potential market for or value of the work. And here Oracle put in evidence that it had suffered substantial harm to both its actual and potential licensing markets, that its licensing fees had been substantially reduced in the current Java markets, which it contended included smartphones, and it had been blocked from entering the new generation of smartphone platforms. So, I would say finally, its major policy argument was that, look, no company is going to make the investment required to launch a groundbreaking work like the Java platform if a competitor can copy it precisely because it has become so popular and well established. And the result will be that corporate giants with vast resources will benefit because they are able to release new versions very quickly. And then I'll just say a word or two about the government's position, because the government took Oracle's side and generally agreed with Oracle's position. So I'll just add a couple of quick points. And one is the government said, look, read in light of the entire statutory context, the section of the statute that excludes protection for ideas and methods of operation, section 102B, should be read to foreclose copyright protection only for the underlying ideas or processes that are implemented in a program, not for code that performs a function or causes the computer to operate. And while Google and a number of the amici asserted that there was an industry practice of reusing this type of code, the government pointed out that code is often reused pursuant to open use licenses like the GPL, which are premised on ownership of a copyright. I know we are low on time. Just to say, let me make one point about fair use. The government agreed with Oracle's points on what was a transformative use and agreed with the Federal Circuit that the record showed overwhelming evidence of harm to the market, including Oracle's ability to license the platform for use in derivative works. And the bottom line in the government's brief was the point that fair use shouldn't permit a new market entrant to copy valuable parts of an established work to attract developers to support its competing product. And I think it's just important to make one last point about interoperability, the concept of interoperability. So this was both sides put forward arguments about interoperability. The government's view was that any industry practice of reusing code to achieve interoperability didn't support Google here because Google had purposely designed the Android platform not to be interoperable with the Java platform. And that, in fact, had been the sticking point in the licensing negotiations. And also, not all interoperability is the same. The term can be used to mean different things. So the Copyright Office has recognized that copying limited amounts of code from one software product into a competitive one for purposes of compatibility is generally a fair use. But this is a different type of interoperability, which had to do with enabling developers to draw on their pre-existing knowledge of commands used on the Java platform. And that is a different use of the term than the way it's used in the Copyright Act or judicial decisions or Copyright Office publications. So I'll leave it at that and just say that obviously the majority didn't agree with most of these points, as we will be discussing.
All right, thank you, Shira. Let me turn to David and for him to outline Google's arguments. But first of all, in the spirit of full disclosure, Shira mentions the government's position. When the government's brief went in, I was the Undersecretary of Commerce for Intellectual Property, and Shira was the Chief Policy Officer at the USPTO at that time. And on the other side, Peter and David, the other two panelists here, filed an amicus brief at the Supreme Court in support of the Google position, at least on the copyrightability side. So with that, David, tell us a little bit about Google's arguments, first on the copyrightability question and second on the fair use.
Good. Okay. Thank you, Andre, and thank you to CSIS for the invitation. Lovely to be here today. The copyrightability argument really takes us back a century and a half. So going back 150 years to the 1870s, there was a man named Charles Selden who wrote a book about double entry bookkeeping. The book was subject to copyright protection, and Baker came along and copied the method of double entry bookkeeping. In the resulting copyright infringement case, Baker v. Selden in 1879, one of the most important decisions for the whole IP structure of our country, The Supreme Court decided this is not copyright infringement. Copying the particular locutions would have infringed the copyright, but the method of double entry bookkeeping is something that's outside of copyright protection. And indeed, in Justice Bradley's memorable words, it would be a fraud upon the public to protect that absent the laborious procedure of obtaining patent protection. So therefore, Google premised its argument on that hoary doctrine, which is incorporated into the copyright statute. Section 102B says that all methods of operation are outside of copyright protection. And in his recitation, Peter talked about the method calls. The APIs are integrally related to those method calls. And so Google's position was that this material is outside of copyright protection. Going back a full decade, the trial judge, Judge Alsop, issued an opinion in which he followed Baker v. Selden and 102B and held for Google. Judge Alsop pointed out that Google wrote its implementing code, which was the vast majority of the APIs. Anyone is free, he wrote, to write his or her own code to carry out the exact same tasks, which is what Google did. Google copied only the declaring code and organizational structure that was necessary for Java-trained programmers to activate familiar tasks. Hence, the copyrighted material was a system or method of operation. So that was the basis of Google's first argument, to follow what the trial court did, which of course was reversed by the Federal Circuit.
David, before you move on to fair use, and maybe I'm jumping ahead a little bit, but I can't help but just ask, which I also asked Shira. Obviously, you know, the Baker v. Selden case came well before computer software. Computer software was added to the code at the end of the 1970s in Section 102B. Isn't all computer software a method of operation? In the end, isn't every line of code calling on the computer to do something? So if we are to apply that logic to the and take it to its logical conclusion, wouldn't theoretically all codes fall out in violation of the statute?
Well, of course, if we applied that logic to the maximum extent, you're right, all code would fall out. Let's look at how Congress did add computer software to the Act. In 1980, Congress amended the 76 Act to adopt a recommendation made by CONTU, the Commission on New Technological Uses. CONTU said, we don't know where software should follow. It's not exactly like patent. It's not exactly like copyright or trade secrets. So faute de mieux, we're going to call it copyright protection. But at the same time, CONTU specified that it's always legitimate for anyone else to cause a computer to do the same thing that, for want of a better term, the plaintiff has done. So a plaintiff who has protection over the copyright of computer software can never stop anyone else from accomplishing the exact same tasks with the computer, which is very similar to what Baker urged when he was fighting against Selden. Computer software is not a stranger to the regime of Baker versus Selden. The so-called case of the century in the 20th century arose exactly in the computer software realm. It was called Lotus versus Borland. And it went to the US Supreme Court. At that point, the question was, how was the Supreme Court going to resolve it? And the issues were incredibly similar to Baker versus Selden. Lotus had, we'll call it a spreadsheet, Lotus 1, 2, 3. Borland copied the commands that were known to a large base of third parties, and it went to the First Circuit. The First Circuit said, this is a method of operation, and it is outside of copyright protection, very similar to Baker versus Selden. When the matter arose to the Supreme Court, instead of getting the definitive case of the century 25 years ago, we got a whimper. The Supreme Court was evenly divided, and so there was no resolution. So now, 25 years later, we finally get the resolution And I think the court, I was hoping, joining into Professor Manel's brief, I was hoping that the Supreme Court would take by the horns the issue of copyrightability to determine that what was copied was a method of operation, just like Judge Alsop had ruled. But instead, we get to the second issue. So should we go to that now?
Yes.
And
So, please, fair use.
As Shira outlined, fair use is an affirmative defense depending on 4 factors. Google argued that the factors favored it. First of all, it pointed out that Sun had made Java free and encouraged its widespread usage. Then it went through the 4 factors, focused on its view that the Android software that it put out was transformative. It was for an innovative smartphone platform instead of what Java had traditionally been used for. And then Google went further to argue that fair use encompasses industry customs, and it's been widespread in the industry to copy APIs. And finally, Google had a constitutional proposition, which is that the 7th Amendment guarantees trial by jury. So in this case, it's crucial to reflect that the jury came back after 3 days of deliberation and ruled in favor of fair use. And so Google said it would violate the re-examination clause of the 7th Amendment to go beyond that. The sense of the community, if you will, was expressed by the fair use verdict, and that should stand before the Supreme Court.
Okay, so bottom line here, the Supreme Court agreed with Google on fair use. They did not, they skipped over the copyrightability question again, I suppose. So maybe if they knew ahead of time, David, that this would become the case of the new century, they would have ruled on copyrightability. But I guess they didn't do that.
Well, you know, I find it very interesting to look at the opening pitch. To quote the majority opinion, given the rapidly changing technological, economic, and business-related circumstances, we believe we should not answer more than is necessary to resolve the parties' dispute. If that were actually good logic, then the next district judge to rule should frame her opinion as follows. Unlike Google versus Oracle, this case does not present rapidly changing technological, economic, and business-related circumstances. Therefore, I, as a judge, will answer more than is necessary to resolve the parties' dispute. But you're laughing because that's a ridiculous proposition, meaning that the logic that the majority set up was transparently false.
Well, in fact, even if it made some sense, right, on that logic, you could have said, fine. If you get to pick only one, why didn't you pick the first question, right? The threshold question, whether it's copyrightable, and then you don't have to answer the second one, perhaps.
I completely agree. But that was their prelude for saying, we shall assume that the entire Sun Java API falls within the definition of that which can be copyrighted. Although later on, there's a throwaway line. If indeed it were copyrightable, it is still fair use. So that's the way that the majority structured the opinion.
Okay, so very quickly, there is so only 8 justices participated. Justice Barrett did not. I think she was too new and missed the argument, the oral hearing, that is. But there was a dissent. Justice Thomas joined by Justice Alito. They were not keen on the majority position. Shira.
And by the way, thank God we escaped another 4-4 ruling with only 8 justices there.
Well, I will say the language in the dissent was strong. The conclusion was that the majority, and I'm quoting, the majority has used fair use to eviscerate Congress's considered policy judgment. And it criticized the majority for exactly the point you were just discussing, for failing to address copyrightability, but instead essentially weaving that issue into the fair use analysis. So the dissent said that the fair use analysis was distorted by the court's unjustified distinction between types of code, declaring code as opposed to implementing code, which Justice Thomas said Congress had rejected those types of categorical distinctions. And he said, look, based on the majority's analysis, it's hard to see how declaring code, in fact, remains effectively protected by copyright. And I think it's worth just mentioning two quick points. One is he says, look, it shouldn't matter that third parties invest their time in learning the method calls. And he uses an analogy to a Broadway musical script where actors and singers have to invest time learning and rehearsing it, but the theater can't copy a script owned by someone else just because it wants to entice actors to switch theaters because they already know one part. And I think it's worth just mentioning, obviously on the factors, it said the majority's error taints its analysis of the remaining factors, and the dissent essentially agrees with Oracle. But the last point I just wanted to make is the dissent says the majority's concerns about a potential lock-in are misplaced. First of all, because Oracle always made its code freely available to programmers, but also, and again, I quote, it looks at who the parties are, and it says, if the majority is worried about monopolization, it ought to consider whether Google is the greater threat. So it's an interesting case in part because it is a battle of titans, and you can see that coloring at least the dissent's view.
Thanks, Shira. Let me bring Peter back in. First of all, Peter, on the question of copyrightability versus fair use, the court does not effectively, as we just learned, skips over it. Your brief was on the question of, you and David's brief, it was on the question of copyrightability. Let me just get to brass tacks here. Do you agree, even though you didn't put a brief in, do you agree with the decision on fair use?
Well, we did in our merits, in our cert brief, talk about fair use. And we emphasized that the Federal Circuit had overlooked factor 2. And you'll note that factor 2 ends up being the lead factor in Justice Breyer's opinion. I think that's very important. We were not opposed to the court finding fair use. We just thought that the copyrightability issue was the more important issue, and fair use creates a bit of messiness if parties can't easily know in advance that their effort to implement a declaration or some other high-level feature of software isn't outside of copyright protection, then they are going to face a difficult calculation. Now, I'm going to say that I think the Supreme Court came very close and in many respects did resolve copyrightability. Justice Breyer's opinion methodically builds the fair use analysis on the thinness of copyright and the, quote, method of operation, unquote, character of declarations, a term David explained. The court states, in our view, the declaring code is, if copyrightable at all, so there we go, further than are most computer programs, such as the implementing code, from the core of copyright, unquote. The court cites approvingly the Ninth Circuit's Sega decision, which held that, quote, the functional requirements for compatibility with the Genesis video game console are aspects of Sega's program that are not protected by copyright, 17 U.S.C. section 102B. So I think that there are some pretty good tea leaves here. And I also think that there's never going to be a case quite like this because we are in an age in which there are many ways in which people developing software can protect those works using both copyright and other methods.
But why is it very why does it have very thin copyrightability, as you indicated, as the court indicates? In that first fair use factor, which is the nature of the copyrighted work, Justice Breyer indicates that a lot of people were using it, and it was designed to be memorized by all the programmers, to become like sort of a natural language to them, and so on. But isn't the whole purpose to allow of the development of this language isn't the whole creativity behind it to come up with really interesting nomenclature and structures so that programmers remember it? Why isn't that creative to allow it to have robust copyright protection?
Let me just state categorically that I think computer programming is very inventive if we want to use the term creative, I'm okay with that too. I think that developing an accounting system can be very creative. And that's why we have a patent office, that when people do things that are inventive, we say that you can only protect it if you meet the standards of the patent office. And Sun did acquire patents associated with the Java code, and they are free to pursue that. As we know, that's a fraught area as well, software patent protection.
Oh, because the Supreme Court also has made it difficult under Section 101, 35 USC, the patent code, to get copyright patent protection for technologies that touch on some of these issues.
Well, I urge CSIS to do a webinar on that subject, and I'd be happy to participate. But I think software doesn't fit easily into patent or copyright, and that's why we're here. But what we do have is this hierarchy within the system. And so methods of operation, even though creative, are not eligible if they function as the digital gears and levers of machines. And that's exactly what Java does.
But Peter, the method calls, their names, as you indicated, there's a nomenclature which has enabled programmers to remember them. They could have called them anything. They could have called them frogs, elephants, rabbits, whatever, but they came up with a specific name. Why is that functional?
Well, I think it goes to the nature of network systems. And as terms are used as gears and levers, they become functional. Had they used unusual nomenclature, perhaps people would not have come and learned the language. I mean, the case talks about how Sun invited people to learn the language. And in fact, Sun was itself, as was Oracle back in the early 90s, they were quite opposed to strong protection for software interfaces. And so, we have a complex history in the case. The jury heard a lot of that evidence. Justice Breyer referred to it. And that's why I think fair use was more of a compromise for the court. But at the end of the day, we have this term, I'll say oxymoronic term, that software is protectable by copyright, but its methods of operation are free for others to implement. And that, I think, is a pretty good balance. And that's where we are.
Yeah.
Software is not going to be valuable in 70 years after the death of the authors. Copyright's not a great fit. It would have been better for Congress to come up with, I think, a sui generis approach for software. But this is where we are. We're struggling on the patent side, and now we have a little more clarity on the copyright side.
Okay, thank you. And by the way, it's not unheard of to have a sui generis type of new intellectual property protection. We have that for certain forms of data in the pharmaceutical space and the like, but they didn't do that here. Let me go to the second factor in the fair use analysis, and whether the purpose and character of use. And this is where the courts are meant to consider whether the work as implemented by the accused infringer is transformative enough. Let me go to Shira first. What did the court hold on the transformative point? And then what does Justice Thomas say on that?
Well, the court did find that it was transformative because it created a valuable new product that hadn't existed before. And it's interesting because it is, this is an area where there's a lot of judicial decisions out there going in different directions. The courts have been struggling with how to interpret it. And so this is one area where this decision may end up being used to go beyond computer software or things like declaring code. We shall see. But it does look at the idea that the use helps people create new products. And so the real struggle here between the majority and the dissent is, to what extent is it a new product, and to what extent is it a derivative work which should be controlled by the copyright owner?
So, David, Justice Thomas in dissent says that this new definition of transformability, quote, eviscerates copyright, close quote. Do you agree with that? And what do you think of the way they implement, the way the court addressed transformative?
I think it's a fair criticism that Justice Thomas puts forward in his dissent. To my taste, it is much too broad. There's a term that Barton Beebe uses in fair use, which is stampede. Now, I think people want to stampede should go to Calgary, and that they can have a wonderful experience. But when courts bring all four fair use factors in one direction artificially, that is bad for copyright doctrine. So in this case, the Federal Circuit aligned three of the four factors in favor of Oracle, and then said the fourth one was at best equivocal. Then the Supreme Court turns around and says all four factors favor Google. I would be much happier if the Supreme Court, having started off with factor 2, the nature of the work, and then moved to the substantiality, which was 0.4%, and then said, we agree with the Federal Circuit that there are two other factors that move in the opposite direction. But in the context of computer software, we balance the factors by concluding that this is fair use. And that would have been a very salutary development in the law of fair use. Unfortunately, the majority felt the need to align all four factors in favor of fair use, and it does create dangers for the future. I'm hoping that Justice Thomas's prediction of doom is overstated, but I understand why it's phrased in that fashion. The fact that more creative works come out of the defendant's work is something that, well, let's just take a classic example. If there's a novel that's subject to copyright protection, somebody who makes a motion picture based on that novel has engaged in tremendous creativity that was not inherent in the novel. There's acting, there's cinematography, there's sets and costumes, et cetera, et cetera. So that's wonderful for the copyright system, but it does not mean that it's fair use without permission from the novelist to make a whole motion picture out of it.
So how do you distinguish that from the majority's finding here?
Unfortunately, I think the majority does not grapple with that. And so I fault the majority for not addressing that issue. In fact, on the fourth factor, the majority says that somebody who makes a new film realizes profit based on a novel. And then it goes on to say, but not all profit earned from a new work is necessarily bad. So I find it very unfortunate, which is why I'm saying that the Cassandra-like tone of Justice Thomas's dissent is well taken. I simply hope that courts in the future will cabin the overly broad language of the majority's treatment of the purpose and character of the use and transformativeness in a way that I feel is necessary for the copyright system to move forward.
So because of time, let me skip ahead a little bit and go to the last factor, but there's overlap between the third and fourth factor. But in any event, on the last factor on market effects, overall, the court says, look, the Java code, the original code, became so popular with programmers, everybody was using it. And therefore, it is fair use to take it. So in other words, it seems counterintuitive, doesn't it, David, that, so the more successful you are as a developer, the more market penetration you have because of your creativity or whatnot, the more likely you are to lose copyright protection. And if Java would have created code that very few people cared about and it stunk, then they could have had all the protection they wanted.
Well, the irony that you're pointing out was noted by Judge Keaton, the trial judge in the District of Massachusetts in the Lotus v. Borland case. And he said that it would stand copyright on its head to say that something that is successful does not get protection. Well, that standing on its head is exactly what the First Circuit did in reversing Judge Keaton. And in some sense, it is what the majority does here. Fair use considers the entire environment in which the copyrighted work is exploited and the effects it has on the copyright ecosystem. So in this case, the Supreme Court balanced the factors to draw the same conclusion that the First Circuit did in Lotus v. Borland.
Let me go to Peter and ask you, Peter, the long-term effects on future creativity and development. Some developers hailed the decision as a win for innovation and for future software development. Others in industry said that this will impede future innovation. What incentive does a new upstart Java, for example, of the future might have if they know they're going to lose their protection if they become successful? Where do you think it ends in today's economy?
Well, I just want to briefly go back and say that in 1986, I wrote an article as a law student in a seminar with then Judge Breyer, in which I suggested that the economics of network systems, like what we're dealing with here, would suggest exactly the kind of doctrine that we see in this case. In fact, I used an analogy to trademark genericide. And I'll say scholars in the field told me that this was mixing regimes, and I knew I was mixing regimes, but I was looking at the economics, and I think that's one of the things that comes through, and it is there. You know, whether copyright can fully balance is a question that is on the table now. I think it actually is a pretty good balance because implementing code is protectable. And it took Google an extra few years to do that implementation. They would have preferred to go right to market. They couldn't. Trade secrecy is available. Competitors don't get access to Boeing's software for its aircrafts, some of the most sophisticated software in the world. With cloud computing, many companies can now provide software as a service rather than as a product. That ensures that it will be protected, just as distributing software in object code form used to serve that function. And any company seeking to develop a software platform today needs to think long and hard about collaboration and openness. Ironically, that's how Sun built Java and how Google built Android. Through the Open Handset Alliance, it was open, it just wasn't GPL open. And that's the difference here. Google chose not to use GPL. I think GPL has both advantages and disadvantages. So in the highly sophisticated modern era of computing, I don't think this case is going to really create a problem. I mean, if a new upstart has a platform that they're looking to use lockout strategies for, then that's going to be, I think, a bad approach. But companies aren't using lockout strategies. They're either being very proprietary or they're trying to encourage community development.
All right, thanks. Let me turn to Shira for the last word here. Shira, first of all, the administration, two administrations in a row, in fact, two solicitor generals in a row in the two different administrations sided with Oracle, both on copyrightability and fair use. What impact? So the Supreme Court disagreed, but now it is where we are. So what impact does this decision have on the Copyright Office, if at all? And what's your view of the overall impact on other areas, whether it's music, photography, movies, other code, etc.?
Well, to start with, it won't affect any registration decisions for software in the Copyright Office, primarily because the court didn't decide the issue of copyrightability. but also because when people submit computer programs to us for registration, they tend to include many of these different types of code, and we're not analyzing which elements are or are not protectable. And in fact, we don't normally see the full program. We only require a representative sample of code for a deposit. But as to the fair use aspects, we follow fair use decisions, and we provide summaries of important opinions in our fair use index. So obviously, this will now be the leading latest word on the subject. And we also counsel Congress and executive agencies on copyright issues, including fair use. So this is the law, and we will be counseling on it. But more practically, we're in the middle of a triennial Section 1201 rulemaking process, which some listeners will be familiar with, where we look at whether there should be new exceptions to the prohibition on circumventing technological measures used to protect copyrighted works. And many of the works where people are asking for exceptions are computer programs, and the argument is made that the proposed uses are not infringing because they're likely to be fair use. So this case is likely to be relevant to the exceptions we're currently looking at. In terms of broader impact, look, the court goes out of its way in several places in the opinion to say it's limited to the facts of the case. It's limited not just to computer programs, but to this particular type of code. But on the other hand, there's also a lot of broad language in the opinion, and we don't get Supreme Court pronouncements on what fair use means very often. So obviously, some of those statements are likely to be cited and relied on, and we will need to see how the courts decide to interpret them. So we'll be watching closely.
Well, thank you very much. We'll have to leave it there. Shira Perlmutter, Peter Manel, David Nimmer, thank you so much for being here today, and really for everything you all do for industry and for the copyright, for copyright owners and copyright users. So we'll leave it there. I want to thank everybody who's watching, and in particular CSIS, for your support of our programs. The questions of innovation, intellectual property are central to the American economy, obviously, and to national security. And you have all been tremendous partners in this effort and leaders in the field. Thank you all, and good to see you, and hope to see you all again soon.